So, ang sa aming pong petition ay we prayed to the Supreme Court na unconstitutional ang Executive Order number 2, series of 2016 at ang Joint Circular kasi ang mga ito ay nagva-violate ng dalawang provisions ng ating Constitution, ang right of the people to know for public information at ang disclosure provision, free for public disclosure. So ito po ay nakasaad sa ating Constitution, Article 28, Section 28 of Article 2 at Section 7 of Article 2. Malala na mababasa din ninyo yan sa mga kopya ng aming petition. Maraming salamat.
Siguro, if there are any questions, para satin muna natin si Justice Tony, si Father Robert, and si Commissioner Heidi bago mag-question.
Thank you. The tradition involves the right of the people to information in matters of public concerns. The right of the people. It also involves the duty of public officials to fully disclose to the people matters of public interest. And this boils down to public funds are being used for a confidential purpose. Even if it's confidential, the Constitution says that people have a right to know, and public officials have a duty to fully disclose, unless there is a law providing for reasonable limits. Wala namang batas. Ang pinapakita nila, yung executive order ni former President Duterte, executive order number 2, saka yung Joint Circular na COA, hindi naman ito batas. Because the Constitution says only a law can put reasonable limitations on the right of the people to public information and the duty of public officials to publicly disclose matters of public interest. So yun, the purpose of the petition is to require the Office of the Vice President to fully disclose how she spent the public funds and to ask the Supreme Court to declare unconstitutional the EO2 and the Joint Circular because these are not the laws required by the Constitution. Maraming salamat.
Thank you, Justice Tony. Father Robert.
Yung public trust po ay napakahalaga ngayon kaya inaharap publiko po yung mga public official na nagmamadaling i-disclose yung paggamit nila ng pera. Kasi nga po, alam natin kung paano ginamit yung pera, walang duda ang mga tao. Kaya lang parang hindi po ganun yung kanilang reflex. Mamadali silang itago. Kaya parang nalaman ko kanina na hindi po confidential pala, na hindi na subject to law. Pati confidential funds, hindi present talaga sa COPA, alam ko ba, tinitingnan niya. Kaya lang ang problema. May mga official na ginagamit yung confidentiality ng fund nila as an excuse not to be audited. Sa totoo pala, hindi pwedeng hindi i-audit, hindi mo audit po yan. Kaya bakit po ang mga official natin, naghahanap po ng excuse para hindi ma-audit? Dapat hindi po sila ganun, dapat sila, gusto nila ma-audit sila para yung mga tao walang duda na yung pera po ay kanilang pinaglalaban. Kaya po, salamat po sa mga nag-isip ng damos na to at sana po ay pakinggan ng Korte Suprema sapagkat matagal na po tayo nalulunod sa koneksyon ng mga opisyal na gustong-gusto yung salitang confidentiality which they use as an excuse not to be audited. Everybody should be audited and all the audited documents and results of audit should be presented to the public for scrutiny and for perhaps prosecution if there's a people.
Thank you, Father Robert, and Commissioner Heidi.
Ganito nga rin po sa lahat. Katulad po ng sinabi ni Atty. Caliena, I'm not one of the petitioner kasi nga po it involves the Joint Circular which was issued during my time sometime in January of 2015. However, I would like to clarify certain things. The Joint Circular is audit guidelines. Kung titignan po natin, siguro kailangan din natin linawin na mahirap, hindi naman totoo na sinasabi walang audit. Kasi dun po sa guidelines, makikita natin, nandun lang po yung isang pagkakaiba kung paano po yung prosesong gagawin. Unlike po ng regular disbursement, ang supporting documents nakatat sa voucher, isinasabit sa record officer, sa accountant, sa record officer, kahit sino pwede tumingin. Ito po ay ang documents po, ang supporting documents na naka-specify din po sa joint circular, nakasilip po sa envelope. And then yung representative ng COA sa sinasabi natin office, yung Intelligence and Confidential Audit Unit, bubuksan po niya yung envelope to find out if the documents are complete. So ito po prosesong to nagpapatunay na pinakahalagahan po ng joint circular, yung tinatawag natin transparency and accountability. Kaya nga po hinihinga ng supporting documents. At nakalagay din po dun sa guideline, after 30 days after, kailangan may action ng COA. At the same action din po yun, mag-issue ng report, mag-i-issue ng notice of suspension or disallowances as the case may be. So nakakapuna din ang complete po yung process. Now, napaka-careful po yung balancing yung joint circular dito sa tinatawag natin the requirements of accountability and transparency. Pero nalulungkot lang po kasi ginagamit po yung joint circular para maitago yung information na kinakailangan ng taong bayan. So, nandito ako ngayon tanghali para sumama sa spirit at saka sa paniniwala na it is high time to revisit their audit guidelines. Of course, it is within the mandate, within the constitutional mandate of COA. And it is high time also that the information be disclosed to the public. Kung sinasabi po natin na ay confidential na within the national security, ito po yung matibay po pagkayo dyan. Yung auditors po natin, kung nag-audit yan, hindi kami allowed to access those confidential information. So with that, ang ibig sabihin, the audit report is not confidential, di ba? Kasi hindi namin kami allowed na i-access yung confidential information. So sa tingin ko, it's like any audit report, kailangan na naman ng yan. Pero naman din po kasi yung paraan para po i-handle yung tinatawag natin na sensitivity of information that are contained in an audit report in case na merong sensitive information. Maraming salamat po for the time.
Thank you, Commissioner Heidi. At sana lang paliwanag bago i-open sa open forum. Ito pong kaso natin, although kung titignan nyo naka-title under Vice President Sara, dahil siya po yung gumamit ng confidential fund. But it is not limited to her or her office. It is all throughout local government offices, all national offices that has confidential funds. So this, ang hinihingi na natin, sana ang katapusan nito, ang pagkapanalo nitong proseso nito, nitong kaso nito, is that not only will the confidential fund be scrutinized, but it will always be open to public. So wala akong nakatago. Kung meron man, wala ako dapat nakatago. First, titingnan natin, pwede ba? Number two, kung sabihin nila pwede, ang sinasabi natin dapat, merong guidelines, merong batas. Kung hindi, kung walang batas, dapat po yan. Dapat po, kailangan lahat pusisiin para tama ang paggasto sa mamamayang Pilipino. So ganun po yun. It covers local governments, all bureaus, all departments. Nagkataon lang po, paulit lang, nagkataon lang po na yung 125 million nanggaling sa last year na question. So, hindi ang kaibahan din nito doon sa unang na-file about the confidential fund. It has nothing to do with the transfer from the President to the OVP, but it has to do with the fund itself, the question whether or not the fund is constitutional and whether or not it is subject to open public disclosure and public accountability. So, ganun po. And then, we're now open to questions. Pag may question po, paki-identify lang po at paki-linaw lang po yung question. Siguro pwede gamitin yung isang mic. Pwede ba yan? Paki-ano na lang, paki-ikot na lang kung sino gamit. Ito po. Yes, sir. Lapit na lang.
Good morning. Good afternoon. Jairo Toledo for Raptor. I have three questions po, but the first one is clarificatory question. Medyo technical po kasi masyado yung confidential funds. We're asking to null and void the memorandum guidelines on the auditing of public funds. So yung basic question po ng public, if ever the Supreme Court grants the petition, what would happen to the access to the public funds? Kapag mawawalan mo na po ba the basic access to it? Or kailangan mo po mag-resolve yun for the meantime? Kasi the rules po are, being challenged, and once the Supreme Court grants the petition, there will be more rules to audit. What will happen? What will happen?
If you look at the reply of the OVP, they are saying that they cannot disclose how they spend the money because of the EO. What they're saying is the Constitution requires a law, not an EO. So if the EO is struck down because that is not required, then the disbursement of the money will be like any disbursement of public funds. It will be open to public scrutiny. So what Congress should do is to pass a law to comply with the Constitution to put reasonable limitations. What those reasonable limitations are will be discussed by Congress. But right now, there is no law providing for reasonable limitations, so everything should be open to public scrutiny. Full public disclosure. Kasi the Constitution says, when you spend public funds, there must be full public disclosure. Exception, when there is a law providing for reasonable limitation. Walang batas providing for reasonable limitation. So tayo ngayon, nasa full disclosure tayo. So we have a right to demand full disclosure. That's basically what we're asking. Full disclosure kasi wala namang batas providing for reasonable limitation.
Siguro dagdag ko ang para sa question kung anong mangyayari, may audit ba? Mag-audit pa rin. Ang sinasabi lang natin, they cannot hide behind the EO. They cannot hide behind the circular and say na hindi sila pwedeng buksan or tingnan. Katulad ng sabi ni Justice Tony, we are on a state of full public disclosure. Ang ginagawa nila, they are using the EO number 2 and the OWA circular as an excuse not to be publicly accountable. Ang gusto natin, public accountability as prescribed by the Constitution, subject to any limitation given by the law. Yun ang hinahanap po natin. Sabi nga natin, bigyan nyo kami ng batas. Wala. Kasi nga, kung titignan nyo dun sa aming final, I think yung iba bigyan ng soft copy. Ang ginumang rason ng OVP, ng Office of the Vice President ni Vice President Sara, ay yung EO number 2. EO number 2 is not a law. It's an executive order. It is an administrative act. It is not a legislative act. So it is not one of those given by the Constitution to limit full public disclosure.
Thank you po for the explanation. Last question na lang po since nasagot na rin po in the first two. Second question for Commissioner Heidi po and less than answer po. Nabanggit po kanina ni Justice Carpio whether they should be able to bring for total transparency and all that po. Sa experience po sa COA, with your expertise po sa auditing, ano po kaya mga special recommendations or special specific provisions na dapat po makita sa law to ensure po talaga na makikita po yung balance sa pagitan ng may secrecy pa rin po in some level of secrecy pa rin, but at the same time, may public disclosure na dapat marami.
Okay, you are asking for a law. I am not a lawyer, so I defer to the lawyers in this table. But I can just say na the Commission on Audit has the constitutional mandate to define the audit rules and regulations. The joint circular specifically defines what a confidential and what an intelligence fund is. Makikita na dito sa appeal, very specifically po, na confidential fund tayo nakatuon. So, kung maglabas po ng Congress ang law, of course, po can issue the appropriate guidelines to Congress. May I refer to Justice Carpio for the provision.
Well, right now, there is no law providing for reasonable limitations on the public disclosure of expenditure of public funds. Taxpayers' money, the public officials must be accountable at all times to the people. Exception dyan kung may batas providing for reasonable limitations. Nasa Congress yan, ano ba yung reasonable limitations? Usapan nila yan. Personally, I think, pag military secret yan, intelligence fund, Well, again, we have to make, provide for reasonable limitations kasi military secrets yan eh. Pwede i-disclose yan kung sino yung bigyan mo ng pera, provide information on military secrets. Pero pag civilian agency naman, wala namang military secrets siguro ang civilian agency, so hindi kailangan ng confidence line. Kung confidence line, well, they have to justify kung bakit kailangan hindi disclose to the public. Eh, yung pera galing sa public eh. Kasi tayo, ang nagbabayad tayo ng buwis. Pera natin yun eh. So yung gumamit yan, accountable to us. Sabi nga ng Constitution, public officials are accountable at all times to the people. So, kailangan i-account nila paano nila binaso yung pera ng tao.
Meron pa akong question?
Good morning, sir. Welcome na po sa News Agency. Tatanong ko lang, sir, any answer. Ano po ba yung state ng yung situation before EO2 was passed? Was it more accessible or not?
Yung EO2 was passed because of the Public Information Act. Diba? So, nung lumabas yung batas na Public Information Act, ibig sabihin, di ba, nagdiwang tayo, lumabas yung batas, Public Information, para okay, we can ask anything. Kaso kung titignan mo yung after nung lumabas yung batas, naglabas ng EO, si former President Duterte, at isa sa mga exemption dito, in-exempt niya yung confidential and intelligence fund. Ang sinasabi natin, that exception cannot be used as an excuse not to disclose the funds. Why? Kasi an EO is an administrative and executive act. It is not a legislative act. Diba? Ang batas po natin, ang constitution natin, our highest law of the land, ang constitution natin sinasabi, subject to law. Hindi po batas ang EO. Kaya hindi ang sinasabi namin, dapat yung provisions ng EO na yun, unconstitutional, it should be struck down because it is against the spirit of our constitution. Pangalawa, kung titingnan yung GAA natin, di ba, ang status natin, line budget, line item tayo. Hindi tayo lump sum. Kaya di ba, kung maalala nyo, in-strike down din yung pork barrel dahil ayaw ng lump sum. Ito, hindi lang po ito lump sum. Hindi lang po ito pork barrel, secret pa. So double whammy sa taong bayan. So sinasabi natin, unconstitutional ito, being an unidentified budget, and number two, because it is being used as an excuse to not disclose the use or the proper use of public funds. Baka may gusto idagdag yun. Okay. Any other?
Sir, para mas malinaw lang po sa lahat, saan po ba dapat ginagamit ang confidential at saka intelligence fund? Of course, alam natin yung sa military ganyan, pero po, kasi kung may mga civilian na agency po. Sir, saan po, para po mas malinaw sa lahat at sa publiko, saan po ba dapat ginagamit ang itong confidential at intelligence fund na ito para lang po mas malinaw sa publiko?
As a choice, medyo klaro po yung provision ng joint circular. Naka-define po doon, ang pinaka-basic na pagkakaiba ang sila yung po confidential are for civilian agencies. Ano po? Ang intelligence po, ito po yung for sa military or security agencies. Ito po yung pinaka-basic distinction. Nandun din po yung satellite intelligence. Yung pinagkagamitan, basically ito po yung surveillance operation, intelligence gathering, pero distinction lang ang conflict sa civilian agencies. Ang intelligence para sa military.
Siguro para well, yun na nga sinasabing na kasi secret ito gagawin sa pang ano ng contractor. Pero di ba open bidding tayo under our new bidding rules, di ba? Dapat meron ng submission ng requirements na, let's say, NBI certificate or clearances, etc. etc. So, pwede ba yun o hindi? Yun po ang tanong natin. Because for now, wala akong guidance. So anybody can just justify it and say, ito po ang ginamitan namin. Ito po ang guideline namin. But since there is no guideline, we are saying that that is not allowable at this point in time. Because unless otherwise it is in a line budget, dapat nandyan yan. Kung hindi, wala siya sa confidential or intelligence fund, depending on what agency are we talking about. Okay. Any addition? So, okay tayo. So, inantay lang natin yung nakatatak para sa kung gusto ng picture later. But if there are any other from the media na wala pa ng soft copy namin para you would have a full understanding kung sino yung mga kasama as petitioners at sino yung mga kasama na as respondents. Makukuha nyo si taas na dito may Attorney Army. Ayan, nandiyan si Attorney Army. Kung kailangan nyo ng soft copy, paki-text lang sa kanya and she will give you a soft copy. Si Attorney Lynette, nandun sa SU, isang lawyer din sa pamaganda, ang ganda ni Attorney Army, kasama natin kanina. Pwede rin siyang hinga ng soft copy. So, siguro any final words, parting words before para makapag-lunch naman, nakatali gutom na eh. So, simulan natin sa ladies first. Almighty.
I think kakaiba po yung panahon ngayon, very interesting kahit pinauso mo yung tinatawag natin kung babalikan mo natin, meron kami tinatawag na IU, irregular, unnecessary. Ito siguro yung pwede sabihin unconscionable. Kasi hindi natin makonsensya yung amount na paggastos. So, inibitahan po natin mga bayan para maging bulat at maging pulis sa mga takbo ng pagbabantay ng pera ng bayan. Mahalaga hong step ito towards transparency and accountability. Salamat.
Una sa lahat, nagpapasalamat po kami sa inyo. Thank you for your presence today. Sa aming mga co-petitioners po, maraming salamat sa inyong desisyon at tumayo at maglakas loob na questioning ng confidential funds. Of course, nandito po sa atin ngayon si Justice Tony. Maraming salamat sa inspirasyon at sa ating mga kabataan. Maraming salamat dahil kayo ay tumindig at tumindigan sa issue nito. Maraming salamat.
Comment pero tanong rin, magkano sa confidential sa intelligence fund na nakaraan ginamit para ipakulong si Laila de Lima na gumagamit ng mga peking mga testimonies. May mga nagamit pa. So, may malinaw po ang misuse ng pondo, lalo na sa paggawa ng mga maling mga hakbang laban sa mga taong may magandang intention pero kinatatakutan at kinagagaya. So, yun po, ang gobyerno po ay lahat ng pera na gagamitin ay para sa pagbukilan ng tao. At kung ano ang mga tao yung sasalita at ang layo lang ay tumulong, baka po sa kanila.
Kasi may mga balita na the OVP and other civilian agencies kinanggalan ng confidential fund. Hindi po kasi pwede sa susunod na kongreso magbigay sila ulit ng confidential fund. Kailangan po natin, sabi na nga kanina, ng ating batas, ano ba ang standard? Tanong nyo na rin, kailan ba gagamitin? Hindi po malinaw yan. tinatanong natin kasi nga wala hong batas kung kailan gagamitin, saan gagamitin, paano gagamitin, at definition natin doesn't mean it issue. Ang issue kung ito, sabi nga natin, transcends law, but future administration, public good, and transparent and accountable to everybody.
Thank you. This is simply an exercise, this petition is an exercise of the right of the people to information on matters of confidence, how the taxpayers' money are being spent. Because we have seen that LGUs providing for confidential funds starting to spread from Davao City, from Makati to Quezon City, and there are no reasonable limitations as required by the Constitution. So this is a wake-up call for Congress to provide reasonable limitations. We really want to give the mayor confidential fund of 360 million a year, or 460 million a year, or 1 billion a year. There must be reasonable limitations. What we are asking really is Congress should enact a law providing for reasonable limitations, because we are reasonable people, and we cannot just say that the local government can decide any amount be given to the mayor to be the confidential fund. We should have reasonable limitations. Thank you.
Okay, so thank you. And siguro, as I said, we'll just have lunch and then enjoy the afternoon. Salamat po sa lahat at salamat po sa inyong pag-aaral. Salamat.
Hindi,